The sitting is open. The court meets today to deliver in open court its decision on the request for the indication of provisional measures submitted by Sudan in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide in Sudan, Sudan versus United Arab Emirates. Vice President Sebtinde and Judges Abraham and Yusuf, who duly participated in both the deliberation and the final vote, are, for reasons made known to me, unable to take their seats on the bench today. I would like to welcome the representatives of the Republic of the Sudan and the United Arab Emirates who are in the Great Hall of Justice today. I recall that on 5 March 2025, the Republic of the Sudan filed in the registry of the court an application instituting proceedings against the United Arab Emirates regarding alleged violations by the latter of its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide in relation to the Masalit group in Sudan, most notably in West Darfur. I shall refer to this convention as the Genocide Convention or the Convention. Together with its application, Sudan submitted a request for the indication of provisional measures pursuant to Article 41 of the Statute of the Court and Articles 73, 74, and 75 of the Rules of Court. In accordance with the usual practice, I shall not read out the introductory paragraphs of the order which set out the procedural history of the case. I shall also omit or summarize some other paragraphs. I shall therefore begin the reading of the order at paragraph 16. In the order, the court begins by recalling that the present case came before it in the context of an ongoing conflict in Sudan that broke out in April 2023 between the Sudanese armed forces and the paramilitary organization known as the Rapid Support Forces and respective armed groups aligned with them. The court observes that the request filed by Sudan on 5 March 2025 refers more specifically to armed attacks targeting members of the Masali group, a people primarily resident in the Sudanese region of West Darfur. In this regard, Sudan alleges inter alia that the Rapid Support Forces have engaged in extrajudicial killings, ethnic cleansing, forced disappearance of civilians, rape, and burning of villages, and that they have systematically murdered men and boys on an ethnic basis and deliberately targeted women and girls from certain ethnic groups for rape and other forms of sexual violence. The court is deeply concerned about the unfolding human tragedy in Sudan that forms the backdrop to the present dispute. The violent conflict has a devastating effect, resulting in untold loss of life and suffering, in particular in West Darfur. The scope of the case before the court is, however, necessarily circumscribed by the basis of jurisdiction invoked in the application. Having made these introductory remarks, the court turns to the conditions that need to be fulfilled in order for it to indicate provisional measures. With respect to the question of prima facie jurisdiction, the Court observes that it may indicate provisional measures only if the provisions relied on by the applicant appear prima facie to afford a basis on which its jurisdiction could be founded, but it need not satisfy itself in a definitive manner that it has jurisdiction as regards the merits of the case. In the present case, Sudan seeks to found the jurisdiction of a court on Article 36, Paragraph 1 of the Statute of the Court and Article 9 of the Genocide Convention. The Court must therefore first determine whether those provisions prima facie confer upon it jurisdiction to rule on the merits of the case, enabling it, if the other necessary conditions are fulfilled, to indicate provisional measures. Article 9 of Genocide Convention provides, I quote, "Disputes between the contracting parties relating to the interpretation, application, or fulfillment of the present convention, including those relating to the responsibility of a state for genocide or for any of the other acts enumerated in Article 3, shall be submitted to the International Court of Justice at the request of any of the parties to the dispute." End of quote. Both Sudan and the UAE are parties to the Genocide Convention. Sudan, having acceded to the convention on 13 October 2003, and the UAE on 11 November 2005, the UAE, when acceding to the convention, formulated a reservation to Article 9, which reads as follows, I quote, "The government of the State of the United Arab Emirates, having considered the aforementioned convention and approved the content thereof, formally declares its accession to the convention and makes a reservation with respect to Article 9 thereof concerning the submission of disputes arising between the contracting parties relating to the interpretation, application, or fulfillment of this convention to the International Court of Justice at the request of any of the parties to the dispute." End of quote. The court notes that no state objected to the reservation of the UAE, including Sudan. The court recalls that it has jurisdiction in respect of states only to the extent that they have consented thereto. When a compromissory clause in a treaty provides for the court's jurisdiction, that jurisdiction exists only in respect of the parties to the treaty who are bound by that clause and within the limits set out in the clause. The court considers the reservation made by the UAE to Article 9 of the Genocide Convention is formulated in clear terms insofar as it concerns, I quote, "the submission of disputes relating to the interpretation, application, and fulfillment of the Convention to the International Court of Justice." End of quote. In the court's view, the omission in the text of the reservation of the phrase, "including those relating to the responsibility of a state for genocide," considered by Sudan to be key wording, does not result in any uncertainty as to the effects of that reservation. This is because the reference to the reservation to the interpretation, application, and fulfillment of the Genocide Convention encompasses the responsibility of a state, which is made clear by the use of the term including in Article 9. Consequently, the reservation by the UAE can only be interpreted as seeking to exclude the jurisdiction of the court over all disputes under Article 9 of the Genocide Convention, to which the UAE may be a party. The court has already found in the past that reservations are not prohibited under the Genocide Convention. However, a reservation under the Genocide Convention would not be permissible if such a reservation is incompatible with the object and purpose of the Convention. The court notes that the reservation of the UAE to Article 9 of the Genocide Convention bears on the jurisdiction of the court and does not affect substantive obligations relating to acts of genocide themselves under the Convention. In the circumstances of the present case, the court cannot conclude that the reservation in question, which is meant to exclude a particular method of settling a dispute relating to the interpretation, application, or fulfillment of the Convention, is to be regarded as incompatible with the object and purpose of the Convention. In fact, the court has in the past given effect to reservations to Article 9. The court thus considers that the UAE's reservation has the effect of excluding Article 9 from the provision of the Genocide Convention in force between the parties. The court concludes from the foregoing that, having regard to the UAE's reservation to Article 9 of the Genocide Convention, this article cannot constitute prima facie a basis for the jurisdiction of the court in the present case. It follows that the court, lacking prima facie jurisdiction to entertain Sudan's application, cannot indicate the provisional measures requested in order to protect the rights invoked in the application submitted by Sudan. In view of the foregoing, there is no need for the court to address whether other conditions for the indication of provisional measures have been met in the present case. The court further considers that, in light of the reservation made by the UAE to the compromissory clause contained in Article 9 of the Genocide Convention, and in the absence of any other basis of jurisdiction, the court manifestly lacks jurisdiction to entertain Sudan's application. In a system of consensual jurisdiction, to maintain on the general list a case upon which it appears certain that the court will not be able to adjudicate on the merits would not contribute to the sound administration of justice. The present case will therefore be removed from the general list. Having come to the conclusion that it manifestly lacks jurisdiction, the court is precluded by its statute from taking any position on the merits of the claims made by Sudan. However, as the court has stated on numerous previous occasions, there is a fundamental distinction between the question of acceptance by states of the court jurisdiction and the conformity of their acts with the international law. Whether or not states have accepted the jurisdiction of the court pursuant to Article 9 of the Genocide Convention, they are required to comply with their obligations under that instrument, and they remain responsible for acts attributable to them which are contrary to their international obligations. I shall now read out the operative part of the order. For these reasons, the Court, by 14 votes to 2, reject the request for the indication of provisional measures submitted by the Republic of the Sudan on 5 March 2025. In favor, President Iwasawa, Vice President Sebutinde, Judges Tomka, Abraham, Shue, Bandari, Nolte, Charlesworth, Brandt, Gomez Robledo, Cleveland, Arescu, Tladi, Judge Ad hoc Cabral. Against, Judge Yusuf, Judge Ad hoc Sima. 2, by 9 votes to 7, orders that the case be removed from the general list. In favor, President Iwasawa, Vice President Sebutinde, Judges Tomka, Abraham, Shue, Nolte, Brandt, Arescu, Judge Ad hoc Cabral. Against, Judges Yusuf, Bandari, Charlesworth, Gomez Robledo, Cleveland, Tladi, Judge Ad hoc Sima. I shall now call on the registrar to read the operable part of the order in French.
Merci, Monsieur le Président. Par ces motifs, la Cour, 1 par 14 voix contre 2, rejette la demande en indication de mesures conservatoires présentée par la République du Soudan le 5 mars 2025 pour M. Iwasawa, président, Mme Sebutinde, vice-présidente, M. Tomka, Abraham, Mme Shue, M. Bandari, Nolte, Mme Charlesworth, M. Brandt, Gomez-Robledo, Mme Cleveland, M. Orescu Tladi, juge, M. Couvreur, juge ad hoc. Contre, M. Youssouf, juge, M. Sima, juge ad hoc. 2. Par 9 voix contre 7, ordonne que l'affaire soit rayée du rôle général pour M. Iwasawa, président, Mme Sebutinde, vice-présidente, M. Tomka, Abraham, Mme Shue, M. Nolte, Brandt, Orescu, juge, M. Couvreur, juge ad hoc. Contre, M. Youssouf, Bandari, Mme Charlesworth, M. Gomez-Robledo, Mme Cleveland, M. Tladi, juge, M. Zima, juge ad hoc.
Judge Yusuf appends a dissenting opinion to the order of the court. Judges Bandari, Charlesworth, Gomez-Robledo, Cleveland, Tradi, and Judge Ad hoc Sima append a joint, partly dissenting opinion to the order of the court. Judge Gomez-Robledo appends a dissenting opinion to the order of the court. Judge Ad hoc Sima appends a declaration to the order of the court. The text of the order is available from today in typescript. It will be available shortly on the court's website. The printed text will be available in due course. As the court has no further business before it today, I declare the sitting closed.